everyone. It is Thursday, October 21st, and I'm coming to you live from Chandler, Arizona. My name is Mark Reel. Welcome to State of the Family Courts. We have a couple return guests I'm really excited to dive into because they do the same thing I do on a day in and day out basis. So we have Keith J. Flinn II, and we have Brian L. Jackson. They are Tulsa, Oklahoma-based fathers' rights attorneys, dads.law. So, gentlemen, thank you so much for coming back on with us. I know we had a great conversation last time. How's everything going in Oklahoma?
Good as always. We're winning, right? Yep.
I will say it's been an adventurous week for me. I'm in Chandler right now, and my younger brother got engaged last night. But this week on the legal front has been interesting because on Sunday I found out that the mother of two of my clients' children, or two separate instances where a mom had been arrested for domestic violence against the father and against the child. So it's been an adventurous week to say the least on my end. But you guys in Oklahoma actually have some exciting changes coming up. Keith, you want to kind of tell people what you guys got passed this year through the state legislature and how the facts, findings, and conclusions are going to impact things?
November 1st, we start at your temporary order hearing. If a court is going to deviate from joint custody, which is the state-ordered preference, the court has got to make a finding of fact and conclusion of law. Now, this doesn't change a lot for most of you, to be honest. It's not the best thing out there, okay? And the reason is because the appeal cost is outrageous. So, yes, abuse of discretion can still occur, but at least we got somewhere. They're going to have to line out the facts and establish a conclusion as to why we're giving it to mom. And I think it's a balance between a fundamental Christian right in our community and the father's rights community here. And they've sort of come out with this politically. It's not the greatest thing ever. It probably doesn't change much for you pragmatically, but at least now we're getting judges to say, hey, I found this, and that's why I'm doing it.
And I think the biggest thing for me is it's a situation now where the judge has to lay out their reasoning. They can't just order it. It's a minute order typed up by the court assistant and is given to the parties. Now the judge is going to have to put some thought into what they do.
Mark, you're 100% right. Now the judge has, yeah, exactly. The judge has to find specific things in order to deviate from what would be a joint custody preference.
Yeah, definitely. And you mentioned something that is a dynamic in Oklahoma that I don't necessarily have in California. And I'll let you and Brian kind of explain this. So rights of fathers and the rights of fathers to be the parent they want to be to their children versus traditional Christian values. So is that something you see impacting decisions in the state of Oklahoma?
Generally speaking, in Tulsa County, you're not going to feel the effects of the Christian fundamental right. But in other counties, it's certainly true that you will.
Yeah, definitely. So that's something exciting. And I don't know the specific details, but I do believe Oklahoma is one of 12 states that in 2022 is going to have a 50-50 bill introduced. So one of 6 states in 2021 that improved their laws via legislation, and is going to be, right now, I believe our count is 12 states that are going to have a 50-50 bill. And I'm about 95% sure Oklahoma is one of those states. So hopefully moving forward, there's going to continue to be improvements to those laws.
We hope so. Yeah.
Awesome. So now I want to move on. We had a lot of discussion around some of the things we talked about last time, so I want to deep dive into them. So Brian, in our last conversation, we touched briefly, we talked a little bit about instances where you get a bad evaluation and you had just successfully defeated this evaluation and had it thrown out. So I want to take a step back, and this is something that a lot of our viewers, that a lot of dads go through, are these evaluations. So when in California, they're called 3111 evaluations. That's the code. That's the family. That's the best interest of the child part of the family code. What are they? Is there any specific name for them in Oklahoma?
Yeah, here what the term that's usually used is like a guardian ad litem appointment and investigation. And I think you had mentioned about what you can do to get your best foot forward on that. In my experience, first of all, I think you want to be as direct and honest with the guardian ad litem as you can. If you have something that you think they need to know about, it's probably better to tell them up front. And if there are negative facts that they're likely to uncover, I think it's better for them to hear it from you than have it be uncovered later by some other person, especially somebody who does not have a dog in that fight. Because if you acknowledge, yeah, okay, yes, I made this mistake, or this happened, or that happened, it takes the sting out of it. There's less, you don't have the effect of surprise. I mean, the same can be true with judges as well. It's usually if you know you made a mistake, you know it's coming out, you're always better to acknowledge it up front as opposed to waiting for the other side to bring it out, and you can sometimes take the sting out of that.
Or getting it sprung at a hearing. That's always the worst, when you have a bad fact get sprung at a hearing. So let's dive deeper on that. So there's a bad fact in the case. There's a drug arrest in the recent history. There's maybe a domestic incident that's occurred. There's been a CPS investigation. When you have that guardian who's an attorney and not a trained social worker, how would you advise your clients to address these bad facts? We obviously want to put it out there, but what is the advice, the tips when they're going to have these conversations? And are attorneys allowed in these conversations with gals in the state of Oklahoma?
You got to be careful here, because if you caught a DUI, you're obviously not going to give any incriminating evidence. If you caught a drug charge, you're obviously not going to give any incriminating evidence. And all of that's going to come through the attorney. And it's not going to be writing. It's going to be a conversation. Right? I mean,
absolutely. And I think to some extent, how you deal with it depends specifically on what stage you're dealing with in terms of, like, if it becomes something criminal, depends on what stage you're dealing with in the criminal process. If this is something that you are accused of that has not been adjudicated in the criminal courts yet, he's right. You want to be very, very careful what you say to that GAL, because it could be a potential witness against you. By the same token, though, if you have a situation where facts are likely to come out that would tend to cause the GAL to conclude that you probably did what you're accused of, there is something to be said, especially in the case where if you have entered a plea, you have been convicted or whatever, there's something to be said for the idea of, okay, owning, yes, I did make a mistake. However, here's what I've done to turn from that mistake, and this is why it shouldn't be the end of the world. And I think it's also worth being aware of what are the specific facts of it. Not all, and it's not to make light or minimize domestic violence, but not all domestic violence cases are created equally.
The other thing that you really ought to point out here is that sometimes guardian ad litems are used by some people to weaponize the court system.
Yes.
Now, and sometimes we get into cases where a particular guardian ad litem with a particular relationship with, one lawyer or another, is appointed, and it's problematic.
Mm-hmm.
The appointment process of a guardian ad litem is extremely, extremely important. And frankly, most of those orders are agreed. And so you should have some kind of a say in who the guardian ad litem is.
Mm-hmm.
In the case that we were talking about where Brian was able to basically disregard the guardian ad litem's evaluation at trial, that particular guardian ad litem had very clear biases based on her receipt of certain evidence from one party and lack of recognition of evidence from another party, and then conclusions that were made based on that, which was very easy for Brian to impeach.
Yes. And I would note, too, in that particular case, I had filed a couple of motions, both asking that she be removed and also asking that any evidence she generated as in the report be excluded. And although the judge did ultimately allow it in, it did have the effect of causing him to look at it harder. And
building the narrative.
Right. I think it's worth pointing out that even if you don't immediately get the relief you asked for in the motion, sometimes it's worth pursuing that argument anyway, because it has the effect of causing the judge to look harder at the evidence, and that can still pay dividends later down the road if you do end up at trial.
Yeah, that's something that I talk ad nauseum about with clients is we may file some things, we may file declarations that we know aren't going to get granted, but it's going to put it on the judge's mind. And I'll give a very specific example. In California, one of the counties, Orange County, that I practice in, we still aren't in person for hearings. That's still about a month off before we're back in person. And the other counties out here, it's been the middle of the summer was when things started picking back up and going in person. And so these judges haven't seen some of these people in person the length of their entire case. The other morning, I brought up in front of the judge, I said, it was actually the judge who technically is presiding over my case. And I was like, hey, Your Honor, I need to do some housekeeping. My case is technically in front of you right now. So I want to make sure you're okay staying on the case. And she went on the record and she's like, I have no idea what your personal situation is. Just so happens I'd never been in front of her professionally. She was like, I have no idea who you are. I have no idea about your case, anything like that. My case has been in front of her for 2 years. So
that's a huge due process issue, Mark. And every time that they asked me to do a hearing virtually, I told them, frankly, that it was violative of my client's constitutional rights, because the public deserves to be here watching you, judge, do your job. I mean, otherwise, what are we doing? We're having private courtrooms. We're having private. I mean, this is absolutely insane. The COVID protocols that have been put in place need to be checked by counsel in every sense. They are public officials, and the public needs to be there to watch them. I mean, otherwise, what are we doing?
I will say, yeah, go ahead, Brian.
I'm sorry to jump in there. I was going to say that is how we keep the system honest, is with public scrutiny. I think the other thing too is in some of these virtual hearings, you can almost analogize it to be the equivalent of putting the courtroom in the back of like a flatbed truck, driving it around the city a couple of times, and then having court. Because I've had several hearings where you have like different login credentials, they change by the hearing, and it creates a situation where you actually have a problem with accessing court for the purposes of seeking justice.
Mm-hmm. And then they are able to exclude family members and other people who are interested. I mean, it's ridiculous.
It really is.
That's one of the things that's been a struggle. I mean, there is still, in California, there is still a ton of restrictions. Many judges have created their own rules where it's the attorney, the client, and then typically the party, the client, can have one support person. And they have these very strict rules around it. So that's something I agree with you guys on that. The one positive that's come of it is the improvement of technology used by the courts. So out here, there wasn't live streaming of court hearings. There wasn't any of that going on. Now we go through COVID where it was forced. We had to do some things online. And now all of that technology has been integrated. And I'll one up you. Riverside County out here, they didn't do video hearings. They did telephonic hearings for about 16 months. Telephone. You dialed in, and then they called they would check in by what was your last 2 digits of your phone number.
I'll posit the Ninth Circuit would have had a field day with that.
Yeah, it's one of those things where it is very challenging because the landscape's very different. I mean, we have, I don't know if you guys have seen what happened to the only In-N-Out in the city of San Francisco got shut down because they weren't properly checking for COVID vaccination cards. So there's been out here, the challenge has been been a great deal of, I believe, overreach by the government that's infringing on I think family courts talking about some of the most important rights and liberties that someone has as a human being.
And where do we go, Mark? We go to the courts, which is the most profound problem, right? I mean, where do you go to address that sort of an issue? And it's the court that's creating a rule that is violative of fundamental due process.
Yeah, I mean, I don't know how you guys had it out here. We had 6 weeks where the courts were shut down. There was very little remedy. A couple of the courthouses. I'm based in Riverside County. A couple of the courthouses were, up until probably about 3 months ago, were only open for domestic violence issues or emergency ex parte hearings. They were not dealing with anything else.
We did have in effect of the way that the courts have scheduled since COVID in prioritizing hearings. We have certainly seen a delay for issues that are not a protective order, emergency custody, or a motion to enforce visitation. Now, albeit I'll say, I can get a judge in front of me on an application for writ of habeas on an emergency, and I can get a hearing in 21 days for a motion to enforce in Tulsa County. And I believe that these judges recognize those underlying fundamental visitation rights and are prioritizing them, which I'm very thankful for. As a father's rights practitioner.
Yeah, I mean, we'll give them credit. They are trying to prioritize those things as best they can.
They are.
I mean, they are, and it's a tough situation because the calendar's been all jacked up for about a year now because of this kind of stuff. So getting hearing dates, if it's not something that's high priority, we're looking at a considerable wait.
And we are not in the business of qualifying bullshit, because obviously you don't want to throw a dumb emergency in front of a judge. So it's for some folks it's definitely prejudicial.
Yes.
Yeah, I would say out here, I think the biggest thing is they've prioritized, because we do essentially, there's the morning court call typically, where it's the short, you're going to have 5 to 25 minutes in front of the judge, and then typically most judges set long form hearings in the afternoon. I think the biggest issue out here is a lot of judges have prioritized and are doing court calls in the morning and the afternoon, and it's situations where if you need a long form hearing, then you may be, I just had one that got set 6.5 months out. That was the nearest date, and that was for a 1 afternoon hearing. That was the earliest that issue could be heard. Now, on what? It was essentially, it was a request to modify. When we have temporary orders, they can get modified as many times as the judge deems necessary. But whenever you request that, I think last time we talked, you guys, it's the temporary order gets set, and you're stuck with that until you go to trial. California, not at all like that. The 2 counties I'm primarily in, it's very rare to go to a final trial. Just financially, it doesn't make sense for the people. Usually, you press the issue until you get to that point, and then they basically tap out. In terms of what happens. Now you get over into LA and Orange, very, very different. But that's been one of the biggest concerns, is when you do need that long form hearing, you do need to put witnesses on the stand, you're probably going to be 6 months out.
Wow.
Yeah.
That sucks. I mean, I don't think it's quite that bad here, but you could be looking at a 60 to 90-day wait to get get some of these kind of hearings, even like with temporary orders.
I think the fastest day you're going to get a trial date is probably 120 days.
Yeah.
So 3-4 months, 4 or 5 months, you're going to get in front of a judge for that long form.
After your temporary order, yeah.
Yeah, and that's always assuming that there isn't some unforeseen delay.
I mean, if everyone's playing ball discovery, there's no legal issues, yeah, you're going to get, you can set a trial date probably about 120 days after a temporary order. But, I've also seen it go 2-3 years, so it's always.
My thing with all of this is that if judges had urgency in handling these matters, I feel like the longer these issues go on, the messier they get. If we had a system that could put you in and in 6 to 12 months have you out with a resolution, that would solve a lot of the messiness that we end up seeing in family court.
Well, yeah, and let's talk about the statute and status quo, Brian.
Oh, yeah. I mean, one of the problems is if one party gets a favorable decision in temporary orders here, it incentivizes, pardon the expression, it incentivizes ass dragging, because what you run into is you get a situation where if they can establish a status quo where that situation's been the case for long enough, you're looking at a situation where the judge is going to look at the other party and be like, all right, tell me why I should disrupt this. Incentivizes ass dragging.
Mm-hmm.
Yeah, I think that's something you see in California, but you can go in and change, and the judge you can bring, even if it doesn't change something right away, you can start to build that narrative of, hey, one party's not being cooperative and this is why. And then you go back a couple months later and say we're having another issue and potentially get some change. But I can see where the one shot and then you got to go to trial to get a change, how an attorney will pull out every trick in the book just to drag their feet to prevent being ready for trial.
Now, technically, under the law, you're not only required as a judge to have one, it's a instrumentation of theirs, effectively, in order to.
Yeah, I mean, it's a funk. I don't know that it's so much of a problem in the more rural counties in Oklahoma, but when you're talking about the like Tulsa and Oklahoma City, or particularly Tulsa, what you're dealing with is you have incredibly busy dockets, and if you try to go back for another bite at the apple on a temporary order, first reaction you're liable to get from a judge is, why do I need to relitigate this? And if you don't have a pretty damn compelling reason many times means there's some kind of an emergency, then they're just going to be like, nope, set it for trial.
An important thing to note here in Oklahoma is also that when we decided how many judges we were going to have, we didn't have protective order dockets. We didn't have the federal implementation of domestic abuse acts, and so the amount of judges that we have is frankly prohibitive in many ways, and we need more judges. I mean, particularly in family court, we need more judges.
We really do. I mean, that's why we get so many special judges, because the courts have a little bit more leeway to appoint special judges than to create like a new district judge position or a new associate. But even still, you're absolutely right, Keith. We're extremely short-staffed when it comes to judges. And then the judges' support staff, it's the same problem.
I think that's something you probably see nationwide, is that the dynamics of the family and the dynamics of the rural family courts developed into playing is they're simply what was going on 15 years ago isn't what's going on now. The number of issues and the number of divorces, the number of, now in theory, if a child is born to parents who aren't married, that case is going to probably at some point need to be litigated. And those numbers are absolutely just going through the roof.
Whew. Yeah, you're right.
Yeah. I think there's a failure to appreciate, too, on the part of the public. If they're not in the system. They're either because they're a practitioner or because they get stuck into it because of personal circumstances. I don't think there's a full appreciation for how much of a problem this really is.
Amen. I say the same thing. I mean, my introduction to it, I was a sports and fitness industry exec. I was a trained labor and employment attorney, and I had no idea the system existed the way it did until I ended up in it personally. And my first thought when I went to it personally was, oh, this is a court in the United States of America. This is going to be quick, easy, fair. This is black and white. And took me about 2 months to realize that is not going to be the case. But the general public, like you said, the general public, or unless you're a practitioner, which I don't know about you guys, I don't think I had a single person in law that I went to law school with that would say, oh, I'm going to be a family law attorney. So I think even a lot of attorneys who aren't directly involved with the system don't understand what goes on. So we'll kind of change. And Keith, you mentioned something that I want to dive deeper on that we talked about last time. And I actually got a few questions from some viewers who did some research into some of the content you put out. And that is probably, I would say, one of the top 2 or 3 issues that men deal with nationwide, probably really worldwide in family court, and that is domestic violence allegations. And you talk about ad nauseum in your content on being proactive and prosecuting and really going after and investigating flimsy and false allegations. So a guy steps into your office and says, I have a protective order, and I have a hearing in a couple weeks, and I've been accused of domestic violence, whether it be physical or verbal, or they're saying I've hit the kids. What are you going to tell that guy? And then what are the first things you're going to do once they retain you to help them with that matter?
Okay, so the first thing I've got to ask is, let's look to the allegation. Is there anything in the allegation that doesn't meet the statute? If that's the case, then, well, we've got a good motion already, right? The second thing I'm going to say is there's 3 steps to this. 1, okay, your first thing is to look at history of communication, okay? Let's look at a prolonged history of the 2 of you communicating. Does that prove up a domestically coercive, a violent relationship? Let's see how many times she tells you in text messages that you're a good dad and does not mention some form of domestic violence. 2, let's look very specifically at the date of the offense and the communications related to that specific time frame. And I want to see the physical evidence, text messages related to that time frame, okay? Because if 6 hours after she's alleging it, you guys are all nice, that's very relevant to a judge, right?
Can I tell a quick story on that specifically?
Oh, of course, yeah.
I had an instance where mom left with the children and then filed for a domestic violence restraining order with very, very graphic, specific allegations. So I tell him, hey, I need all the text messages. I need everything. And he was like a little bit hesitant at first, and I didn't know why. And I'm like, I need everything. And I start digging into the situation, and just hours after she alleged this incident occurred, she had offered, one of her friends was over and had offered to have a threesome with him. So sometimes it's the things you hear as a family attorney. So I'm sitting there and I'm like, okay, so she's alleging at 2 p.m. that you slammed her head against the wall, choked her out, and punched her a few times, then just got up and walked away. In 3 hours, she's like, hey, my friend's over. You want to join us in bed? Doesn't make any sense.
Yeah.
All right, sorry for that interruption, but I had to.
I call it time stamping the allegation. Let's look at it and in terms of when the date of offense is, and let's figure it out. Now, obviously, you have a mode of vehicles in order to impeach her. And unfortunately, a lot of times we're going to be trailing that protective order. We're not going to get the fucking prosecutor to dismiss this thing, when we show up at arraignment. You're going to have to sit. You're going to have to wait. We're going to trail the protective order. You're not going to talk to her for a little while, whatever. And it does impede custody. That's the worst part of it. Yeah. I mean, frankly, that's the worst part of it. And that's why a lot of these women's lawyers are telling them to abuse the court processes because, hey, the status quo Brian was talking about. We can develop a status quo, blah, blah, blah. And it's scary to go to court and get a final protective order. It affects your career, etc. But the reality of it is you need to let us investigate it. We need a deposition. We need written discovery. We need them to produce it because otherwise, guys, it's going to kill you. I mean, it's going to affect the ability that you see your kids for years to come unless we can prove substantial change of conditions and change the underlying decree. It's going to affect your employment when that protective order comes out. And then some employers like, oh, you've got a protective order. If you cop to a misdemeanor that you didn't do, golly, domestic violence misdemeanor? Come on. And then let's talk about the protective order statutes. The federal government here has imposed serious restrictions on your right to even own a firearm. And Brian's an expert on that. So, I mean, I'll let him talk
well, yeah, I mean, if you have a final protective order against you, under Oklahoma law, you can't have a carry permit. You can't purchase a firearm under federal law because you will not pass the NICS test check. And with a final protective order, in most cases, you can't even possess a firearm. Like basically, if you have a gun cabinet, you're going to empty that thing out because you are now.
You have to.
Yeah, you're now legally prohibited from possessing it. And what's interesting too is the way that they're defining what counts as a firearm for the purposes of a protective order could also include things like a crossbow. So if you like to bow hunt,
not the crossbow.
That Red Ryder that you gave your
BB
kid.
Gun.
I mean, like literally, you can't even have the Red Ryder you gave your kid at your house.
And not only that, but an unfortunate thing, at least in Oklahoma, and I mean, I don't know if this is the same way in California, but the way the laws are written in Oklahoma, the problem you run into with these protective orders is it's almost like playing with house money. You throw the dice on a protective order. If you lose the argument, the protective order gets denied. There's really not a lot of penalty, except if it's really an obvious abuse. And convincing a judge to award you attorney's fees in a situation like that, or trying to go after her for some other penalty, you're fighting an uphill battle, even if you win the argument at the protective order hearing.
But then you're res judicata on the other, right? Right.
If she gets it, she's got a res judicata argument on custody that it is against the best interest of the child for you to have anything other than supervised. It's all because it's already been found that there's enough there to get you a protective order. So there you go.
But it depends, obviously, guys, because in Oklahoma, at least, it's present in the home, and so the res judicata argument is always going to be leaned on you if you got the final. If you were dumb enough to show up to that protective order hearing without a lawyer, I mean, it's dumb. Okay.
Yeah.
If you ask the judge to put a protective order hearing on, you're basically asking them to rubber stamp a protective order, unless you've got some good stuff. Okay. If you were dumb enough to do that, now we're in the custody battle. Res judicata doesn't actually mean in the home at the time of the custody order. But you've got to make that argument to the judge. A lot of times, it's not happening. I mean, right?
Yeah, you're fighting a serious uphill battle in that situation. And it's not impossible to win the argument, but it makes it a hell of a lot harder, particularly if you have a situation where there's some specific, something that sounds really, really bad.
Yeah, right.
I mean,
which it always does. I mean,
yeah, because they're going to write those pleadings up to make it sound like a piece of shit. Yeah. And the judge looks at that, and then you either they found grounds or you cop to it, and they're like, oh, you did this, and then you did this, and then you did this. oh yeah, you're a piece of shit. Why am I giving you custody? Why am I giving you unsupervised
And you get a
visitation?
protective order, and it's grounds harassment, okay? Res judicata, and maybe your family judge says, well, that's domestic violence. Well, no, it wasn't domestic violence, judge. It was harassment. Now we've got a protective order out. And the other thing is harassment got to be no legitimate purpose. Sometimes, you asking to see your kid, that's what she's pleading is harassment.
Oh yeah, that's
And you
a lot.
show up to court without a lawyer, and you get nailed on that, that
I think another
destroys your custody.
Another thing guys need to understand, there's a trap that I've seen guys fall into from time to time when they show up in these dockets pro se, is they think, oh well, I'll just stick to it because I don't want to talk to her anyway, and not realizing what the other legal consequences are that go along with having that protective order. And by the time we talk to them, it's already done, and they're like, well, I didn't know it would have that effect. So, I mean, never agree to something until you have a chance to talk to somebody because you just don't know.
I got two things on that. An irony about going in pro se. A couple weeks ago, ours is handled exclusively through family courts, and if you have an open family case, a lot of times that judge will preside over a domestic violence restraining order hearing. Well, I had a case. I got a DVRO thrown out, and we're finishing up the paperwork, everything. I hop on the elevator. A guy hops on the elevator with me. Apparently, he went in pro se after I had been up there, and he's like, hey, I saw you in there. They just granted this domestic violence restraining order. Can you help me out? Like, well, I can't get rid of the domestic violence restraining order now because that ship has sailed. We would have to go through a lot. And number two is the state of California, they actually statutorily in the family code, harassment, coercive control, we have one of the broadest definitions of domestic violence in the family code of any state in the country. And if you're found guilty of domestic violence by preponderance of the evidence, there's a presumption that for 5 years you should not have any legal or physical custody. So these guys who go out there, and I wish I could shake every criminal law attorney who has a dad plead down to something, but you could plead down to some very low level misdemeanor on a domestic violence case, and all your spouse, your ex-girlfriend, your co-parent, all they're going to have to do is trot that pleading in and say, Your Honor, they've pled guilty to a domestic violence charge, and it creates a 5-year presumption. So this is something state by state. I know Nevada has the same exact law, except it is clear and convincing evidence. So it's not preponderance; it's clear and convincing. So you got to know your state's laws, and you need to talk to someone the day it happens. Not get emotional, not lash out, not do anything crazy. You need to talk to a professional and figure out what your options are, because those decisions you make, especially around domestic violence, could have consequences for the next 16, 18 years of your relationship with your child.
Yep. Well, Mark, that California law is bullshit.
That really is.
Family Code Section 3044, it's one of the worst laws in the country, period.
That's crazy. I mean, it makes it.
So it doesn't have to, like I said, it can be they can find you were harassing. I call them mean text domestic violence restraining orders. Basically, a few nasty texts get sent back and forth. Judge slaps a DVRO on them. Then that creates what we call 3044 presumption. And you got to go through a whole lot to be able to rebut that presumption over the next 5 years.
I mean, I get the idea of, criminalizing domestic abuse. I mean, that's one thing. That's fucking absurd.
Yeah, it is.
I mean, basically, there's no incentive to rehabilitate if you do make a mistake.
It's crazy.
It's like you might as well take that to trial, because if you don't
5
take it
years.
to trial,
How many years is your kid a kid?
Yeah.
5 years?
5 years.
Holy
yeah,
shit.
it basically, the statute comes out and says that if you're found by preponderance of evidence to have perpetuated domestic violence, then it is presumed that it is not in the best interest of the child for you to have any legal or physical custody. And it is not an uncommon thing for a guy to come into my office and have had a criminal case, no restraining order in place, no nothing, but there's a custody case that started, and they pled guilty. Their criminal attorney advised them to plead guilty to some like simple battery or some low level misdemeanor, but that automatically creates the presumption because that's beyond reasonable doubt. And now we're talking about a broader definition and preponderance of the evidence. It's I had David Passara on, who is he's a Southern California father's rights attorney, and we talked about it. It's one of those things that the law, I get the purpose of it. Domestic violence is a serious matter, but they've created a situation in family court where weaponizing it and filing it on flimsy grounds, you're most likely, the bar is extremely low. If an attorney files for a domestic violence restraining order, they're probably going to get it granted because you know exactly what to say. You know how to cross that bar. Like, I mean, it's probably less than 10% of DVRO requests submitted by attorneys the temporary orders get denied. So you're already going to go 21 days without seeing your kids, most likely. And then you're going to have to deal with, do I need to set this for a long form hearing? Can we convince the judge to pull the kids out of the domestic violence restraining order? But it's become a play in California. And I've talked with attorneys out here, and a lot of attorneys who do what we do. And the question is, I'm like, do attorneys, when they represent these women, are they digging for this domestic violence? Are they digging for something they can call domestic violence to get an upper hand in this? That's really what's occurred in California. And quite frankly, I think part of the backup in the family court system is specifically because of this issue.
You know, Mark, I was one of the most aggressive prosecutors in terms of domestic violence. I had, very little toleration for it. But at the same time, you got to recognize what the incentive is for these people to make those allegations. And, even as a prosecutor, you're looking at it, and your system, it appears to me like far, far, far more.
Well, prosecutors aren't involved. We're not even talking. This is, if you file for the DVRO, that party that files, the protected party, is prosecuting that themselves. So it's another attorney, it's this person pro se going in front of the judge saying, I need this protective order. So there's no bar to get over. It can just simply be filed. And the TRO can be granted without a response. It's granted without a response. It's just granted on the face of the pleading.
He signs an affidavit. The judge says, okay, that's enough. Let's see it. Right?
Yeah. You submit, literally what you do out here is you submit the petition, and then you submit what you want the temporary orders to be, and you submit what you want the orders to be after hearing. You submit those forms to the judge. And like I said, I would say single-digit percentage of requests get denied. In general, you're going to get that box checked on the front page of the DV-110 is the form that says, or DV-109 that says all these requests are granted until hearing.
Similar to how our protective orders work with an emergency judicial protective order, is basically the judge will rule off the pleadings. I mean, at least here you actually have to fact plead it. So you have to, in theory, you have to show, okay, here's why. But in practice, they're very frequently rubber stamped.
Well, and frankly, people who don't show up get fucked.
Mm-hmm.
People who show up without a lawyer, it's a he said, she said, preponderance.
If you show up late, you can get fucked that way.
Yep.
And I think there's a failure to appreciate how serious this is, and there's really not a huge penalty for abusing these things.
Yeah, no.
I mean, you might get your ass chewed by the judge. I've seen that happen before.
Technically, you can get attorney's fees. That's rarely ordered.
Yeah.
So we have something, attorney's fees in California are thrown around left and right. We have something where it's screwy with the law. So if you file for that domestic violence restraining order and you prevail, you can go after attorney's fees.
Yeah, that's good.
statutorily, it doesn't explicitly address if a domestic violence restraining order is filed against you and you prevail and get it thrown out. It doesn't explicitly give you a path to request attorney's fees.
Same here. You've got to go under the case law.
Yeah, I mean,
Yeah,
there's that, but you have to basically show it was frivolously filed and there was no victim.
No victim.
Yeah, and that's a very high burden. And the other thing is you get a situation where judges don't want to discourage victims from filing these. So you're really talking about having to show a case where it was obvious abuse. I mean, the case that we always cite to in our motions is the Pierman case.
Or finger.
Yeah. Well, and Pierman basically what the nut of that case was is you had a situation where it came out in evidence undeniably that this person had filed a protective order specifically to give her friend an advantage in custody litigation. And in that case, attorney's fees were awarded. But I mean, that's
it wasn't a domestic litigant, so it's another.
Yeah, and I mean,
there's a bar to cross. Yeah.
I wanted to comment on another problem. I don't know if you're seeing this here. I know I see it a fair amount, and I think you see this a lot too, where you have judges in protective order court who allow evidence to be considered that wasn't pled into court. Like they'll come and plead in like harassment or some particular incident that they say justifies this protective order. But then when you actually get to the hearing, they're bringing in a bunch of other crap that they never mentioned in the pleadings. And it's a coin toss whether the judge will let that in or not. A lot of times they will, and then grant a protective order on something that was never pled into court.
Yeah, that's something we see out here. You show up, and a lot of times you'll get someone that pro se they filed this domestic violence restraining order, and they attach some random documents, a couple screenshots of text messages, and you look at the client and you say, okay, we're going to show the full roll of text messages. We have this couldn't possibly have happened. And you show up in court, they have an attorney and they have a binder of evidence, and they're like, Your Honor, this is what we're like. We have 21 exhibits and we're going to have 3 people testify. And it's like, these people weren't even mentioned. And in California, you file for that, you have 21 days. The only mechanism of discovery you have to get to gather any information in that 21 days is to basically immediately notice a depo and serve it upon the party. Because if you want to file any written discovery requests, it's 35 days in California, so they don't have to respond until after the hearing. So the only method
here in Oklahoma, I mean, yeah, we'll continue an emergency and do discovery. We can do depositions and written discovery.
Mm-hmm. Well, the struggle is out here, if you continue that matter, you may not get back on calendar for 4, 5, 6 months. So obviously there's a huge deal of seriousness to the matter and the consequences, but you're sitting there and it's like, especially when you look at a pleading and you respond to it and you're like, there's nothing here. We have evidence that contradicts all this stuff. And then they show up and you're looking at them like, hey, we're going to have to wait 2, 3, 4, potentially 6 months before you get your day in court. And we're going to have to beg the judge and plead with the judge to remove the kids from this restraining order in the meantime.
Yeah. Oh, the judges will remove the kids almost as a matter of course. If you don't file an emergency custody order here in Oklahoma, those judges are going to remove those kids.
9 times out of 10, yeah.
Yeah, I mean, unless it's like you're filing a protective order because somebody sexually abused a kid or something. I mean, that's like, they're going to throw out the kids off the protective order.
Yeah, the only other exception I've seen is if you're talking about a particularly egregious example of violence where the kids were there. I mean, I think I had one involved where there was an allegation involving a firearm like that, but again, it's not the typical situation.
Yeah, because they're going to at least order supervised for even the shittiest dads here, I think. I mean, yeah. Most times they're going to give, like, you got the worst guy shows up to your office. He's probably going to get supervised visitation.
Maybe not even get that. I mean, it may be one of those deals where the judge will just say, well, we'll put him on weekends and see how that flies.
This is why I was so surprised about the rating that was given to Oklahoma last time we were talking. Like,
I'm sure, based on, and they're due to update him, I would be very, very shocked. I think it said Oklahoma, they were a D plus with the facts, findings, and conclusions of law. And based on how things operate now, just the facts, findings, and conclusions, if you deviate from the joint, that right there, come November 1st, probably puts Oklahoma in the B range. Just having that simple fact, because with the work I do for the Fathers' Rights Movement, we look at three things when it comes to custody litigation. We want a presumption of 50-50, then the burden of proof we want, like Arkansas has, which is clear and convincing. Kentucky has preponderance of the evidence, and then we want facts, findings, and conclusions of law. Like the state of West Virginia in 2021, they didn't get 50-50, but they got facts, findings, and conclusions of law if the judge orders 35% or less custody to one of the parents. So basically, the judge has to justify as to why he's limiting access of one of the parents. So yeah. I want to dive deeper here as we wrap up. This is one of the most common questions, and we'll dive a little bit deeper. Obviously, it's not going to be the full fleshing it out, but one of the most common questions I get, and this a lot of times is within the false allegations, the flimsy allegations, or if they just make general in the custody dispute, substance abuse, violence, whatever it may be. So I'll start with you, Keith, and then we'll go to Brian. So in my opinion, the most powerful mechanism we have to start figuring out information is written discovery. We have the interrogatories, request to produce, request to admit. So someone comes in on a custody issue and they've levied, I call it the Holy Trinity, the substance abuse, the mental abuse, and the anger issues. And they allege all these things. How can a dad leverage these written discovery tools to at least start their fact-finding expedition?
Well, of course, your investigation, if in a cost-effective manner, written discovery is great. I want to start off with the weakness here, which is evasive discovery response. I think the reality of it is, and why you need to hire us to do a deposition, is because it's far harder for her to evade my questions in my office. Reality of this is, time and time again, what you're going to find is that when you ask questions in written discovery, they're going to give you whatever they pull out of their ass as their answer. And it's, and then I've got to litigate written discovery. I've got to send deficiency letters. I got to talk to their lawyer under the statute. Got to talk to them before I'm going to file a motion for sanctions. But, at the same time, Mark, I understand what you're saying. Obviously here with production, I get to say, hey, give me this. That proves what you're saying. Interrogatories, I get to say, hey, not as good. I usually use interrogatories more in a financial and or a list witnesses aspect, but admissions, probably the most important aspect of written discovery is admissions. And personally, I send production interrogatories and I do deposition before I send admissions. And here's why. Because I'm not asking you to just admit shit. I'm asking you to admit stuff I can already prove. And I can prove it. And now, if you don't admit what I'm saying, there's going to be penalties associated with not admitting it. Request for admission, the most important piece of discovery, the last piece of discovery. Did I answer your question, Mark?
Yeah. I think that points out to one thing in particular: having a professional that understands the strategy behind it. So I agree with you. Request for production can be extremely powerful to start out with, because you're going to force them, like you mentioned, financial. Hey, give me your bank records. Hey, I need to see your Cash App account. I need these records, or it could be documents. There are a lot of times I've noticed when things get nasty where they withhold documentation, they hide documents, they destroy documents. that are actually property of the other party. Well, now we're going to put it on the record. We're going to put it in discovery that we need you to turn over those documents. And in California, a lot of times you can ask for them to turn over any evidence they're going to use at trial. So then when they come around at trial and they show you something they didn't produce at that time, oh, did we find this between the request and trial? Did we create this between the request and trial? It can create some doubt. And I think depositions, extremely powerful. I think the biggest challenge, I don't know if you guys see this, is the cost. It's going to cost a couple $1,000s to bring them into the office. Obviously, there's going to be prep work for it. You got to have everybody in there that's going to be necessary, the court reporter, all that stuff. So if you can gather some information and then you get them on the record, because, I mean, Keith, you said you're a prosecutor. You rarely would ever put someone on the stand in other areas of law if they haven't been deposed. Like, if there's a multi-million-dollar business litigation case, every person that goes on the stand is going to have been deposed. Like, no one's going to go on the stand, but family court, we have this pay-to-play system essentially in place that prevents the full finding of information.
Yeah, I couldn't agree more. Pay-to-play.
Yeah, there seems to be a lot of, I mean, I would go further and say there's one area of law where you have trial by ambush.
Yeah.
It could seem that way, particularly on your protective order document.
Oh, yeah. And in fact, there are plenty of it. There are individuals, I won't say plenty of individuals, there are individuals who will try to leverage the trial by ambush strategy in protective order court with this idea that, I'll just blindside you.
Yeah, goes back to what I said. They show up, they filed pro per, and then they have an attorney when the hearing rolls around, and the attorney's got a binder full of exhibits that you've never seen before.
Yeah.
And
not only that, you get a court-appointed lawyer when they're drafting their affidavit. They get to go to the Divis lawyers over there. They walk them through what they need to write, and then they show up.
Yeah.
So they're getting a free lawyer while they're prepping this thing, while they're lying their ass off, calling you some kind of a dickhead, and then you get nailed when you show up to the hearing.
Yeah. Okay, so we'll take a couple questions here. I want to hit this one. This is an Oklahoma specific question. So this was just DM'd to me on Facebook. So I was arrested for a domestic violence charge, and the prosecutor dropped the charges. And the family court judge is now holding those charges against me in our custody matter. So if you get an instance like that in the state of Oklahoma, how are you dealing with this arrest that occurred, but then the charges being dropped?
Well, Judge, it didn't meet probable cause. They actually declined to prosecute this. Now we're here on a preponderance of evidence, which is a higher standard of proof. How can you even validate that, right? Unless we're going to a hearing where you've got witnesses that are testifying, blah, blah, blah. But just the mere fact that somebody's charged and then they're dismissed. No, I mean, no judge worth their salt is going to.
I would add, too, I think if you're dealing with a situation like that, you definitely want to make a record.
Well, yeah, of course.
Yeah, because if the judge is going to do that and consider an accusation to add up to, oh, well, that makes you guilty. Okay, Judge, let's put that on the record. And, here's what I have to say about that. And I think you're exactly right. Like, look, this is probable cause, and we have that. That's a lower burden than preponderance. If she wants to bring in, if she's going to bring in evidence and witnesses to support that allegation, then we can talk about that. But otherwise, I want it on the record that you're going to take this allegation as evidence.
I think every judge in Tulsa County will hear her evidence. But no judge in Tulsa County will hold that probable cause of evidence.
No, I agree.
Okay, so it sounds like it's something that if that's occurring in the state of Oklahoma, you need to get the judge on the record as them making that finding that right now there's been domestic violence.
Yeah, I would agree with that.
So let me find another question or two here.
I would subpoena the cop too, and yeah.
All right, so I'm digging through these. I got this really isn't a question. Tennessee is pretty hopeless as well. Tennessee was one of the 6 states this year. They did get facts, findings, and conclusions of law added in this year, and they are one of the 12 states that's going to have a 50-50 bill get introduced. And right below that, we got, what about Missouri? Missouri, the same thing. They've had a 50-50 bill in the legislature for, I think, the last 5 or 6 years. It will be getting reintroduced this year. I believe it got held up in Senate committee last year, but they're
Yeah.
so yeah, 100%. I was just at a conference about a month ago in St. Louis and actually had the opportunity to interact with some of the legislators that are pushing this. If you're in either of those states, if you're in any state, you'd be surprised the impact of you picking up the phone and calling your legislator, especially if you're in a state where it's either small population or large state legislatures. These people may only represent 15, 20, 30,000 people. And how many of those people are actually calling their legislators? If you have a group of 5 to 7 people that are calling state legislators asking for this, it's going to get on their radar. I said we're at 12 states are going to get introduced this year, or 12 states as of today that are going to have 50-50 legislation introduced. We have 2 that already have let 50-50 legislation on the books. So if that's something you want, if that's something you are pushing for, do a quick Google search. If you can't find who your state representative or state assembly person is, or who your state senator is, I really don't know what to tell you, but the snowball's rolling downhill.
I'll tell you. If you want to email me, I will tell you who your representative is. I promise.
You're a bold man for making that proclamation. So, all right. So this is a quick one just to clear up. So 730. It looks like Ryan, you put 730 and corrected it. Yeah, 730 and 3111 are similar in the state of California. One's under the evidence code, the other one's under the family code. Small differences, but yeah, those are the evaluation where they're found in the code. All right, I had another one here. Let me get back to it. We'll wrap up with one more question here. All right, so I'm going to kind of parse this question apart because I think it's a good one and it's something we talked about earlier. So Ryan here, they dragged their feet for 11 years on a modification, then said they would not have any more hearings. So what I want to pull that to is, you talked about in Oklahoma, you got the one shot and then you're going to trial. What do you do when opposing counsel or the opposing party is dragging their ass and is not moving forward, maybe not playing ball on discovery or whatever the necessary steps are to get to trial?
Call them every day. No.
It sounds like this is an issue that was dealt with today in the
office. Probably the starting point would be the proverbial nasty gram, or the official term is deficiency letter. It's like, okay, you haven't done this, you haven't done this, you haven't done this, and you want to establish that paper trail so that and then if they're still not cooperating, you file your motion, and then you have the paper trail to take to court with you. Show the judge, look, I tried on this occasion, I tried this, I tried this, I tried this. They're not playing ball. Jack them up.
Yeah. No, I agree. The other thing here is, why is it being delayed? Okay, so we need a pretrial conference order. So you're going to send, emails periodically, sign this pretrial conference order. If there's a discovery problem, make that clear. Otherwise, what's the fucking holdup, frankly, right? And call them every day.
Yeah.
I mean, I've called lawyers incessantly on cases where I thought they were holding up my clients. So,
I'm sorry to jump in there, Keith. Another tool you can use to proactively avoid that problem In Oklahoma, you can get the judge to enter a scheduling order, which puts deadlines in place. And that's a good move to do early on, especially if you have a case where you know it's going to get ugly. You know, you have people that really hate each other, or they have a lot of assets, or there's kids and they really disagree about what to do with the kids. You get that in place because it puts a clock in place, and that will force them to move along, because if they blow a deadline, they're going to have to explain to the judge why they blew the deadline.
And I think, unfortunately, some of this is that I always tell clients in the micro level, for the individual, the court process moves slow. I can tell you, for at least in my experience in practicing, it feels like it moves a lot faster for attorneys, and for people that are in court every day. And if someone's not playing ball, it just simply is going to take more time, because of all the steps you mentioned. So that's just one to start.
We're going to push really, really fucking hard for settlement. The way that we play the game, we're going to get you the deal you deserve, unless they're just fucking stupid. And then we'll take them to court.
Yeah.
Great point there. The best resolution in a custody matter is usually when the two parents can find that common ground. It's not having the judge slap on what a lot of times, let's just be quite frank, is some boilerplate plan that may not work for the family.
If you want a judge to cut you in half and say, she gets this, she gets that, he gets this, he gets that, you know, that's fine. We'll do that for you. The best case resolved by y'all figuring that out. The problem is splitting the kid. Mm-hmm. That's always the problem.
Mm-hmm.
If she is just too stupid to come to terms, the judge is not going to like her.
Tell us how you really feel.
I think there's another added problem, though, when you're dealing with domestic cases in general, whether it's child custody or whether it's just property, is because these involve relationships and it's deeply personal on a unique level, I think, to the parties involved. You get egos in play that I don't know that it comes in play as much in other areas of litigation. And sometimes people will let their ego get ahead of their brains. And
that's why the judge has the gavel, right?
That is. But I think it's also where one piece of advice I like to give to clients is this idea of, I mean, particularly if you're fighting over money, do you want to save money, or do you want to be right? Because you may not be able to do both at the same time.
Yeah, and you can be absolutely right as a pedestrian in the street and get
hit by a car because you stepped out in front of one. So you're dead right.
You could be right at the crosswalk and get absolutely nailed, guys. Yeah.
I will say one of the funnier conversations I feel like on a regular basis I have is when you have a woman who doesn't work and a guy who does work, and in California they're probably going to get attorney's fees, and you look at the guy and you say, hey, this is a pretty fair deal, and I think we can get out of this by offering to pay $2,000 in attorney's fees. I'm not going to pay her attorney's fees. And I'm like, well, it's going to cost us $2,000 to litigate out these attorney's fees. So you're going to pay this $2,000 no matter what.
Either way. Yeah.
Yep.
And they just kind of blankly stare at you like, I don't know what to do now. So, hey, we're coming. We're at about an hour and 10 minutes now. So we'll wrap up here. I want to thank you guys for coming on. Obviously, they can find you at dads.law. Do you want to tell them where they can find you on social media? And I know you guys have a Facebook group.
I'm at Tulsa ESQ on Instagram, and we've got the Father's Rights Support Group here, Facebook. Thanks, guys.
All right, so, hey, thank you guys for coming on, and we'll do it again soon.